What does it mean when the Court of Appeals stated marijuana metabolites in a DUI case were not retroactive? Attorney Brian Sloan says, "A few months ago, the Arizona Supreme Court stated they were not concerned about inactive marijuana metabolites, meaning they were not concerned if someone had been driving with the inactive THC, called carboxy-THC, so it would not be a DUI if that was found in the person's system while they were driving and were physically in control of a vehicle." This ruling basically undid decades of thought that simply having the inactive marijuana metabolite in one's system while driving could be a DUI conviction or could lead to a DUI conviction. Many attorneys, myself included, went back on previous cases where someone only had the inactive marijuana metabolite in their system, and we filed motions with the court to get the case overturned because of the Arizona Supreme Court ruling that came out and stated that what everyone had thought for the last couple of decades was not true. I had taken on about 8 cases and had 6 of those cases overturned, arguing that the person should never have been convicted in the first place because someone had pled guilty to something that was not a criminal offense. Some of these cases involved my past clients, whereas some of those were other attorneys' past clients. Some other attorney in the Arizona Court of Appeals for Division 2, which is the Tucson area, argued that someone's case should be overturned because they previously pled guilty of a DUI that only involved the inactive marijuana metabolites, and the trial judge denied that motion. The defense attorney decided to take it up to the Court of Appeal. The Court of Appeal recently issued a published opinion saying that even though the Arizona Supreme Court stated inactive marijuana metabolites plus driving, or being in actual physical control, would not be a DUI, they technically did not overturn any previous case law, that even though for decades attorneys and judges were always under the impression that inactive marijuana plus driving equaled a DUI. There is no case that specifically states that a person could get a DUI by driving with inactive metabolites in their system. The Arizona Court of Appeal recently stated that when the Arizona Supreme Court ruled a few months earlier that it was not a DUI if the person had inactive metabolites while driving, then it was actually a case of first impression because the Arizona Supreme Court was dealing with it for the first time. They really considered what the definition was for a DUI and whether metabolites truly included inactive as well as active metabolites. It was the first time they were defining the law as opposed to overturning an old law or overturning old court cases that interpreted the law. It was not a retroactive ruling for people who had previously pled guilty to DUI drugs and who had inactive marijuana metabolite or any other inactive metabolite in their system to be able to come back and say their conviction should be overturned because the law had changed. They basically stated it was people's own fault if they were not aware of what the law stated, even though that was what everyone thought the law was. Everyone, including prosecutors, defense lawyers, and judges, truly believed that was what the law was for decades, until the Arizona Supreme Court stated it would not be a DUI if someone had an inactive metabolite in their system while driving, and that would only be the case from the point forward. This meant that no new convictions could be made if someone was found with inactive metabolites of marijuana while driving, or really any inactive metabolite while driving, although someone who had pled to it previously would not be able to have their case overturned. The Court of Appeals case stating that inactive marijuana metabolite would not be retroactively applied is called State v. Werderman. For a free phone consultation, contact attorney Brian Sloan in Phoenix, Arizona at 602-357-8980 or visit him on the web at www.arizDui.com.